Ladies and gentlemen, do you not know that you have a right enshrined in the Constitution of the Federal Republic of Nigeria to adequate compensation when your property is compulsorily acquired? How much were you paid the last time a portion of the fence wall of your premises were broken just for the dualization of the road? My name is ESV Stanley, your celebrity valuer, and today I'm going to be throwing a little light on compulsory acquisition by governments or acquiring authorities, the role of estate surveyors and valuers, and then the remedies that are available for landowners, why they shouldn't be cheated. So we're going to be taking our time to look at it in a robust manner with intention to inform you. If you're not informed, you're definitely deformed. So when we talk about compulsory acquisition, there are also conditions on the side of the government. Yes, we know the land has been vested onto the governor to administer, but then it has to be done for the overriding interest of the public. What do you mean by the overriding interest of the public? You must use that land for something that will be much more beneficial to the public. So it has to be for hospitals, it has to be for stadium, dualization of road, infrastructure. Those are overriding interests. So the government can come acquire my land, even though I have a C of O, certificate of occupancy on that land. They acquire it compulsorily for the overriding interest. But also the Constitution provides that adequate compensation should be made while acquiring that property. So you're cheating on yourself when government acquires your property and compensation is not paid. Right? So what I'm going to discuss today is to open your eyes to the things that are legal about compulsory acquisition, the role estate surveyors will play in that scenario. I'm not in any way talking down on the perfection of your title. It is very good for you to have a perfected title. In other words, governor's consent or C of O and all whatnot. But then that is not a condition for any acquiring authority not to pay you compensation. As long as you own the land and there is a development on the land. The law says that they must pay for the inexhaustible development on such lands. So you have a building, you have a fence, you have a grave, you have an economic crops on that land, and government wants to use it, the government pays compensation for it. Now, it is incumbent on the government or the acquiring authority to appoint an estate surveyor and valuer to represent them in costing the compensation value to be paid to those that their properties will be acquired. So if government appoints his own acquiring valuer, then it's also incumbent on you to appoint your own valuer. Now, the reason is this. If government valuer comes and says, this your property is going down, and half of it will go down, so they are measuring the half that will go down to compensate for it. And because you're a layman, you don't even know that there's something called injurious affection. That when part of your property goes down, definitely the lifespan of the remaining one, because they are all on the same foundation, is already reduced. So paying you X amount for just that point that will be demolished, right? Instead of paying for the entire property because of injurious affection, it's a disservice to you. And you're putting yourself in a disadvantaged position during such acquisition. And not just get any attorney to represent you during compensation. It's better you get an estate surveyor and valuer who knows about value to represent you, so that when the government valuer is saying your property is worth 10 million, for instance, your valuer that knows the same thing like the government valuer who understands valuation can come and say, no, this property should be paid 20 million. These are my reasons. Until they both compromise, get to the same page, right? Indemnity will not be given. What is indemnity? Signing that you have allowed the government to demolish your property because the compensable value is okay to you. And until the indemnity is signed, nobody has a right to break your property. So the first information I have for you, know that it's within your right to appoint your own estate surveyor and valuer to represent you during compensation. Don't go for attorneys, don't go for agents who just wants to collect a percentage. No. go for a valuer and talk about the value that is due you that will leave you better than it met you, or at least put you in a place of compensation. And the compensation is going to be the value of today. That you built the house with 1 million naira 10 years ago doesn't mean the house should be valued at 1 million naira today. It will take the market comparison, to take the inflationary trend to get what you're due today. Ladies and gentlemen, it is a disservice to you. My name is ESV DK Stanley, your celebrity valuer and the lead consultant of Sendai Consulting, in terms of estate surveyors and valuers. I'll be back in our next post to tell you more about the remedies that are available for you. Where your property is compulsorily acquired and compensations were not paid, what remedies do you have? That's why I would say, don't be too intelligent to a point where you close your ears to relevant information. Consult an estate surveyor and valuer today. I'm a celebrity valuer. Catch you in my next post.